I've only had one client in my 42 years that said, "Hey, I'm okay if we go to prison," when they walk in the door, right? Most of them, they say, "I don't want to go to prison." No shit, Hoss. Neither does anybody ever that's hired me say, "Hey, Cogdell, can you get me some prison time?" The reality of that, though, is particularly when we consider the sentencing guidelines, and we'll get into that in a minute, the downside to trying a case is catastrophic. I'll give you a real-world example. Just today, I met with the U.S. Attorney on a matter. I won't go into the details of it. And he sort of there's what is called a reverse proffer, and a reverse proffer usually in the federal context is a situation where your client will sit down and listen to a prosecutor summarize what he thinks he can prove at trial, right? And most federal prosecutors, not all, but most federal prosecutors will kind of give you the highlighted version of what they think they can prove at trial, so your client can hear it from somebody else other than their lawyers. And surprisingly or not, sometimes the client will trust what a prosecutor is saying to them versus what their own lawyer is saying to them, because in their mind, we're going a little bit sideways, they're thinking, well, I paid this guy $100,000 and he's already gotten his fee, so he's just telling me to plead because he's already earned his money and doesn't want to have to work for it. That thought process occurs. But again, just today, we sat down, my prosecutor and an FBI agent and my client and Teaser Pony, my associate, where this prosecutor kind of walked through, in 2 hours, hey, these are the 25 things I think I can prove, and here's how I'm going to prove them. And by the way, if you lose and get found guilty, you are at a level 45 under the sentencing guidelines. We'll get into that. But 43 and above is life. Life, as in coming out in a pine box, you ain't coming out ever, life. So his exposure under the sentencing guidelines was off the charts. And so when we came there, and again, I'm not going to violate a privilege, but the thought was, dude, I don't want to do any time. Well, when you consider the offer, which is a 5-year cap, that 5 years looks pretty damn good compared to coming out in a pine box, right? So it is not infrequent or not that all unusual when a client considers what their exposure is, and it's like, well, look, in 5 years in the federal system, if I can do it in a camp and I'll get out in 2.5, 3 years, by that time my daughter's going to be a junior in high school and I can still provide and I can still restart my career and we can get through this, as opposed to I'm never going to see the birth of my grandchild. I'm never going to be there when my wife is going through cancer treatment or whatever. So it's the hard reality of the exposure, particularly in the federal system and to be fair, in the state system as well.
For a plea agreement, does it matter how good the criminal defense attorney is?
That's a really good question, because a lot of times people think, well, shit, if I'm going to plead guilty, why do I need to go hire a Gerger? Or why do I need to hire Rusty Hardin or Cogdell or whomever? The reason is simple. The better the lawyer, generally speaking, the better plea offer you're going to get. Not always, but usually that's true, because a prosecutor has to consider and should consider a number of things: how fair it is, how dangerous the defendant is, what the evidence is, how compelling the evidence is, what their exposure is. But one of those things they're going to consider is how good the dude they have to try the case is. And they don't want to lose. Whatever a prosecutor wants to do, they don't want to lose, particularly at trial. So do I believe a better lawyer will get a better plea bargain offer? You're damn right I do. Absolutely. Now, the problem becomes, Tommy, when a defendant hires a lawyer and he gets an offer from a prosecutor and he doesn't like that offer that his first lawyer is relaying to him, and then he says, well, let me go hire another lawyer. I'll get a better lawyer. Well, guess what? The prosecutor's first reaction when I come in or someone else comes in is, hey, man, I already gave John Smith an offer. I'm not going to give him a better offer than I gave you, right? Oftentimes they move off that, but that's where they start, because that's human nature. Prosecutors don't like to be played. They don't like to be big dogged or whatever. So I understand that notion. But the fallacy comes in from a defendant who doesn't understand the real life consequences of the fact that your first lawyer is really going to sort of set the tone for how a prosecutor is going to view your case. And it's not necessarily going to get a whole lot better because you hire a whole lot better lawyer later on. Spend your money and your time and your focus on getting the best lawyer you can from the beginning.
So if I hire a lawyer and they come back to me with an offer and I really don't like the offer. Hey, I'm innocent. Hey, this is not fair. Hey, the offer sucks. I feel like my lawyer is not doing enough. Is there any validity to get another lawyer or
There is, but the problem is, I mean, and I got a call just yesterday on a federal matter. Again, not violating the privilege. This woman is set on a serious matter in front of a very serious judge, and she had hired a good lawyer. I know the lawyer that she hired, right? And she paid this lawyer $50,000. Okay, he's a good lawyer, probably deserves that and more. But she didn't like the offer that she got, and she said, "Hey, what's your fee?" And I said, first off, my fee's a lot more than that. Second off, don't expect me to fly in there like Batman with a new cape and get you a better offer just because it's me. Because the prosecutor's going to say, hey, just because I hired Cogdell or you hired Cogdell or hey, Cogdell, I'm not going to give you, I already gave John the offer I'm going to give you. So you make that clear, or you should make that clear to the potential. Look, I got shit to pay for, Tommy, just like everybody else, right? I got bills. But I'm not going to incentivize a client or try to persuade a client to hire me with some promise that I'm going to get a better offer than the lawyer that they already got. I won't do that.
So, I mean, I know every case is different, and this is probably a case-specific question, but let's say that the person really doesn't want to take the deal. Should they just take it, or should they get another lawyer?
They should certainly talk to other lawyers. Maybe their first lawyer has missed an issue. Maybe their first lawyer has a skill set that's going to benefit them in that particular case. Maybe their lawyer has a great track record in those kinds of cases. I mean, Aaron, you sent me a case a while back where some friends of yours owned a vape shop, and they had hired a really good lawyer who was trafficked in that area, and I talked to them, and I said, look, I can sit here and charge you $250,000, but you got a good lawyer who knows the issues. Stay with him. If it goes sideways later on, then give me a call. But don't spend your money just, sometimes changing a car doesn't change the destination, right? You can spend more money on a Ferrari than you can on a Suburban, but if you're going to end up in the same place, you need to think about that.
You mentioned prior as well, one of the way that the system is structured is that, one plea can lead to other pleas. In my head, the first thing that I thought of was like snitches and rats, right?
You're thinking exactly yeah.
So on that topic, I mean, you've worked with several different people over the course of your career, and I'm sure you've seen more than you can remember in terms of different situations that have gone down. But this whole concept of don't be a snitch, don't be a rat, like how viable is that? And how often?
Everybody in prison is a snitch.
Everyone in prison is a snitch.
A lot. So let me talk to you about a thing called the federal sentencing guidelines. And obviously they apply only in federal cases. But the federal sentencing guidelines were part of the 1984 Sentencing Reform Act. And believe it or not, I was licensed in 1984, and I remember them proposing these things, and I'm going, Jesus Christ, this is crazy. But what the historical purpose of the sentencing guidelines, which became law in, I think, 1987, was this. Judges didn't really have any sort of template to judge people by and sentence them by. The argument was, a bank robber in New York goes in, robs $5,000, shoots 2 holes in the ceiling, and that judge is going to give him 5 years in prison. When another bank robber goes into L.A., shoots 2 holes in the ceiling, robs $5,000, and that person is going to get, probation. There ought to be some system, something in play to make the sentences more predictable, more uniform, more consistent, and more fair. So they enacted the sentencing guidelines, and the sentencing guidelines, the oversimplified, are you start out with a number, a base offense level number, and that number is adjusted up or is adjusted down by so-called aggravating or mitigating factors. Guess what? There's a whole lot more aggravating factors than there are mitigating factors. So they consider, for example, the amount of loss, the 2B1.1 table, where how much money was in play, whether or not violence, whether or not it's your first offense, whether or not people were hurt, whether or not you have vulnerable victims, whether or not it was a complex all these different ways of adding them up. shout out, throwback to that conversation I had just today, where by the base offense level of this particular offense, he was looking at 6-8 years. By the time you added up all the aggravating factors, it was 43. It was a level 43, actually a level 45. So we went from, hey, it could be 5 or 6 years, to guess what? You're never coming out. It's a pine box. So when you add all those numbers up under the sentencing guidelines, they translate to a number, and that number presents a range in months. It's 120 months to 142 months, which 10 to 12 years, whatever. Those guideline numbers used to be binding, right? Until 2005, the Supreme Court came down with a case called United States versus Booker. They were mandatory and binding on a judge. It was very difficult for a judge to vary from them because they were binding. In 2005, still around then, the Supreme Court said they are advisory and not mandatory, which means judges can consider them and should consider them, but they're not bound by them. But fun fact, even judges that weren't around pre-2005 still view the guidelines as sort of their starting and their ending point. So here's where we get to your question. The best way to get a variance or departure in the federal system is called a motion for downward assistance based upon a motion for downward departure based upon substantial assistance, a 5K1.1 motion, which means if you snitch and you lead to someone else getting prosecuted or convicted, we'll come in and help you. So guess what? Everybody says, oh, I can't be a snitch. I can't be. Dude, every cellmate you got has either tried to get a 5K1 or its post-conviction counterpart, a Rule 35. Everybody in prison is a snitch. Every single one of them. They may act like they ain't, but they ain't. I would venture, and I don't have any empirical data, Aaron, to back this up, but I'll bet you a good 75% at least either got a 5K or a Rule 35 or tried to get a 5K or Rule. They can talk, quien es más macho, I'm the baddest, I'm the baddest soldier on the planet, until they're looking at that 20-year versus that 5-year sentence all they want.
Dang, that's crazy. So if my 20 can go down to 5 by just like ratting him out.
Yep. You're going to take that every time.
Shit.
And you're not even going to think twice about it. I mean,
you've seen brothers.
I have seen brothers testify against brothers, fathers testify against their sons testify against their mother. Every single day that stuff happens. And it's tragic in one sense because the prosecutor has that much discretion, because I can jump up and down all I want, no judge variance, and he had a hard, troubled background, and a judge is going to look at me like a cow at a new gate. So, these are the guidelines, and I'm considering them, so what else you got? But when the prosecutor stands up and says, well, Your Honor, he assisted in the prosecution of A, B, and C, then we're going from 10 years to 2 years. Then we're going from 20 years to 8 years. It literally happens every day. And the system is based upon that, right? It assumes cooperation. It assumes plea bargains, right? Because the system couldn't stand otherwise. There's no way it could withstand it if everybody chose to go to trial.
Yeah, no, that's
When you see somebody who doesn't want to rat somebody out, do you, I guess, look at them and you're like, all right, that's kind of badass?
I have had one guy in 42 years of doing this, and I mean, he was a straight up soldier, right? He was a cartel dude and a straight up, just as nice of a fella as you'd ever want to be, and until he wasn't. But he was going to get a level 43. They offered him substantial assistance on a matter that would have cut that in half, at least. And he's like, I'm not going to do it. I ain't going to do it. Nope. I'm not going to be a snitch. I mean, one guy in 42 years. And I admired the shit out of him. I didn't quite understand it because, you got to do what you got to do. But one guy, and he's still in. He'll probably be in forever. Wow. But he's like, I ain't going to be a snitch. I ain't no snitch. I ain't no bitch. I ain't no snitch. And, and you do have to admire that.
Yeah.
So that isn't just in the movies. That's actually at least happened once.
It happens, but it's rare. It happens, yeah. Wow. I mean, all those mob cases in New York City and Philly. I mean, look at who brought Gotti down. A fucking snitch. Yeah. They all snitch. It always comes down to that.